Uddhav Thackeray's decision not to face a floor test has proved to be a very expensive one for him and his faction of the Sena. This is because the Supreme Court has said that just because he didn't face a floor test, it cannot reinstate him now as the Chief Minister of Maharashtra, which means huge relief for Eknath Shinde and the Sena BJP government in Maharashtra. They will continue to be the ones in government for now because of this Supreme Court decision. Remember, Sharad Pawar also had recently talked about how he thinks that Uddhav Thackeray should have faced a floor test. He should have put up a fight. And now even the Supreme Court saying that had he actually faced the floor test, even if he had lost it, at least it would have been clear who was on which side. And because he didn't face that floor test, now it's very difficult to restore status quo ante, which means to restore or reinstate him as the Chief Minister of Maharashtra. Here are the other key points that the Supreme Court made in its verdict. Now, what happens if there is a speaker against whom there is a no confidence motion? Can that speaker decide on the disqualification petition of MLAs? On that accord, the Supreme Court has actually said that this is something that should be dealt with a larger bench. So now, a 7-judge bench, a larger bench of the Supreme Court, will take this up to decide on the powers of the speaker. The other thing also the Supreme Court says is that the speaker must decide on the disqualification of MLAs within a time-bound fashion. The Supreme Court has also said that the Election Commission should decide on the political party and its spread or its support not only on the basis of the number of elected representatives it has, because political parties are more than just legislative parties of those political parties. As far as the governor is concerned, the Supreme Court said the governor was wrong in entering the political arena. The governor had no business to get into internal affairs of a political party or intra-party affairs, and in this case, it seemed to have been done by the governor. The Supreme Court also said that the governor only relied on material evidence, which was not objective evidence, to show that any of the rebel MLAs had actually showed him or tried to show that they had withdrawn support from the FMA government. And because there was no written or objective material before the governor on whether those MLAs had decided they no longer wanted to support the MVA government, the governor should not have asked for a floor test. So that one crucial decision taken by Uddhav Thackeray to step down, to resign before facing a floor test has now to prove to be a very, very expensive one for his faction of the party. One more thing that the Supreme Court talked about is that the whip issued is not only meant for those, or the whip issued should not only be limited to the elected representatives. Yes, they are elected representatives. They can actually put in place a person who is the whip of the party. But the whip should reflect the realities of the political party. So the Supreme Court said the appointment of Bharat Gogavle, who is from the Eknath Shinde faction, his appointment as whip was illegal.